Welcome to the special interview for With the Legal Time, an initiative of All India Law Student Federation. Even almost after 4 weeks of government acting, there is a lack of clarity about what exactly happened to Article 370. Has it been abrogated or de-operationalized? What is history behind this article? What is the impact? Today, we will talk about this issue with the gentleman who has served judiciary for more than 2 decades. He is on former Chief Justice Patna High Court, current Chairman Punjab Human Rights Commission, Honorable Justice Mr. Iqbal Ahmed Ansari. Let's start with Article 370. Sir, can you tell us about the brief provision and what is Article 370 to our large audience?
You see, in order to understand Article 370, it would not be possible to clearly appreciate without the legal history behind Article 370. Because what powers have been given and what powers have now been withdrawn, that will depend upon how clearly we understand Article 370. I think all of you must be knowing that under the Indian Independence Act 1947, India was partitioned and divided into two dominions. One was Pakistan, the other was India. There were many princely states in India, more than 550. Now, they were given the option that you can either go to Pakistan or you can go to India. And one of the principles that you have the option of not joining anyone. And that is precisely what happened in the case of Jammu and Kashmir. Maharaja Hari Singh, who was obviously the king of Jammu and Kashmir, he decided not to opt for either. That means his population was, majority obviously was Muslims, so he was unwilling to go to India and at the same time not willing to go to Pakistan. And in this background, so that if it would not have been possible for a princely state not to join any dominion, obviously Jammu and Kashmir would not have seen the history which it has seen, because then the British people would have told, or the British government would have told Maharaja Hari Singh that you have to join one of the two. It's not necessary. One, of course, broad principle was that states, princely states, which were contiguous to the dominion concerned, preferably it should merge with that. Say, for instance, Junagadh was one, Hyderabad was another. These were princely states, obviously, but they were far away from Pakistan. So Nizam trying to go to Hyderabad would not have been possible. And similarly, though I don't know how many of our people know it, that there was an instrument of accession already signed by the Nawab of Junagadh with Pakistan. Ultimately, when India took, because there was, after India took over, a plebiscite, and I think only 96 or some votes were cast in favor of joining the Republic of Pakistan. Now, this was the background. So when Pakistan raided, regular army raided Jammu and Kashmir to take it over with the people dressed as tribals, Maharaja Hari Singh found that he was unable to fight a regular army. It is one thing to fight a rebel, and it is quite another to fight a regular army of another country. So he asked for help from India. So the then Governor General, Lord Mountbatten, he said it would not be possible for us to give you any assistance unless and until you join. That means you accede to Republic of India. Now many people say that no, Maharaja was wanting, India did not send its forces. No, India could not have sent its forces. That's why they could not have done it. Anyway, so Maharaja ultimately agreed and he signed a treaty of accession which he sent from there. That instrument of accession is also very important because it had only 3 subjects which had been given to India. One was defense, external affairs and communication. These were the 3 subjects which are in the Union list 1 of our constitution under the 7th schedule. Now with this, the instrument of accession was accepted by the then Governor General. So that's how Indian forces reached there. One more controversy which has been raised in the recent past, which with no legal backing, is that notwithstanding the fact that there was an instrument of accession by all the princely states giving only these 3 subjects to the Union of India, but as a matter of fact it was a full accession. No, there was a document of merger which has been signed by all the states except the state of Jammu and Kashmir. Jammu and Kashmir did not sign the instrument. So now in that event India sent its forces. They defeated the Pakistani forces disguised as tribals, and then of course the UNO intervened and the ceasefire took place. Now when the problem here arose that in order to administer Jammu and Kashmir, there were many things which were required. Supposing there were currency, whose currency will prevail there? Supreme Court of India, how it will have the jurisdiction there? Which will be ultimately the court, right? So there were so many others. So secondly, when we say defense, it does not mean it ends with defense. It means many other items which you will find in yes. There are I think about more than 10, 12 items there, like armed forces, etc., etc. Then ordnance, so many other things are there, because otherwise these ordnance factories are set up under the Union list only. So this is how the 3 lists were. So then it was agreed that in the meanwhile, let me tell you that there was already a constitution of Jammu and Kashmir when Maharaja was there, and another constitution was being framed, because this was new development, not the development of joining India, but the development of getting complete independence from the British. That is why, so there was, so then it was decided that they will have a constitution of their own, right? Now assuming in course of time you find that this is a subject which Union shall deal with, that means India should deal with, right? It can happen. So then you need a power. How will you get the power? That's why this Article 370 came. So that there, by and large, it is that with the concurrence of the Constituent Assembly, because there was already a Constituent Assembly. India had a Constituent Assembly making its constitution. They also had a Constituent Assembly. Their Constituent Assembly is subject to their concurrence. President of India can promulgate a notification, saying that these are the powers which will apply. And similarly, these were the powers which will cease to exist was also given there. So this is what Article 370 basically is, in short, that it gives the power to Union of India, subject to concurrence of the Constituent Assembly of Jammu and Kashmir, to exercise legislative powers. And obviously, once you have the legislative power, you have the executive power also on such subject which are not.
Sir, Article 35A comes with Article 370. So can you tell me, can you brief us about Article 35A, and what is the relation between Article 370 and 35A?
35A, there was already a law in Jammu and Kashmir promulgated by Maharaja Hari Singh himself, because Jammu and Kashmir does not have much of land. It is a vast area, but these are all hilly terrains. So agricultural land is very small. So that's why they wanted a kind of a protection. And that's why Maharaja Hari Singh said that in case any outsider marries here, then he will not have, or his successors in interest will not have any right to the property ultimately. Uh, anyway, because then this Article 35 later on came. Because many people say that no, it was not passed by the parliament. No law is passed by the parliament. Whatever so far we have applied to Jammu and Kashmir is by way of notification of the President of India, and that is precisely what we did. The only thing is that the Constituent Assembly of Jammu and Kashmir was dissolved once they made their constitution, whereas Constituent Assembly of India was only adjourned sine die. It can still be restored. This is a very important and dominant difference between the two. So this is what Article 35, and this is nothing new. It has in Himachal also. You can't go and buy. In Northeast, you can't buy. You can't even carry on business in your name. Unless you want to take any contract, you will have to take it in the name of a tribal. Even within Assam also, in the tribal dominated areas, even an Assamese cannot buy. Oh, so it is not peculiar to.
So everyone is talking about one nation, so can we consider India to be one nation and one constitution? Can you explain about this one nation concept? Whether it can be possible?
It had never been, because India is a very, it's almost a subcontinent. You go in Europe from one part to the another, you will find the same thing. Roads are same. After some time, you forget which country you are traveling through, because these are all small countries, and it has the same kind of a countryside, almost the similarly. In India, with you find that there are so many languages, so many culture. I belong to Guwahati High Court. There was a time when Guwahati High Court used to deal with 7 governments. With the result, you had 7 political parties to deal with. You had 7 different languages which people spoke. You had different culture. You had different cuisine. You can't. It's not the same food style. Your weather, climate, everything is changing there. So it is so diverse. You can't have one law, one nation. If you make it one law, one nation, then in that event you will have to take out all the rights of the not possible, because that will lead to tremendous. And again in language, though Hindi is a national language, many states have already started protesting, and ultimately it has been said that no, we are not going to make it compulsory. So this is how it is.
So there is a lot many articles about Article 370 that Dr. the father of Constitution, Dr. B.R. Ambedkar, against the inclusion of Article 370. So whether this is correct, like how you can say, what is your say on this?
In fact, let us understand this very clearly, that as far as the Constituent Assembly was concerned, of India's Constituent Assembly, it had people not only from Congress but others also. And it had all those people who subsequently objected to 370. For instance, Shyama Prasad Mukherjee was there, Dr. Ambedkar was there, everyone was there. So now it is said that Ambedkar had, there is nothing. I have tried to check it, and I have tried to check it from those who are supposed to be authorities on Ambedkar. There is no such thing that Ambedkar had ever objected. As a matter of fact, when you see the debate of the Constituent Assembly, you will find that for the inclusion of Article 370, no objection. If there was no objection, and these are not the people, Dr. Ambedkar was not less than anybody else. He would have objected if he had the reasons to object. Shyama Prasad Mukherjee was a very independent minded person. He could not. Yes, later on they might have realized that it was wrong or whatever it may be. Whether true or false, we don't know. But at that time, he has not. And now recently, the government of India has already published where it is. It has been written that his proposal was Dr. Ambedkar's, that Kashmir should go to Pakistan and Jammu and Ladakh should come to India. Secondly, when at the time when 370 came, Nehru was living for some foreign country, most probably America, and he requested Sardar Patel that get this 370 passed by Congress Working Committee because they were in majority in assembly. So this 370 was first passed by Congress Working Committee and then placed in the Constituent.
Not something that it was done at the back of my mind. Because if I have an objection, it has to come in the Constituent Assembly on the floor. There I don't say anything. Now you will say you have an objection.
Sir, why and when Maharaja Hari Singh left J&K, leaving behind Karan Singh as Sardar Riyasat?
Nothing more than that. Because and obviously you can't blame him also in the sense that when he does it, after all, Sadr Riyasat had only a nominal figure. After it had been reduced into a constitutional monarchy, in the constitutional monarchy, just like United Kingdom, the king has no power. Everything is done by the legislative assembly. That is what was being done that time.
So you talk about merger instrument. So whether any document is like there.
Yes, but so far as Jammu and Kashmir is concerned, there is nothing. No merger.
So how we can like.
That's why 370. That's what I'm telling you. Because there was no instrument of merger, India had an option to apply provided that the Constituent Assembly gives the concurrence or sees if it gives the concurrence. Now, what the government of India presently has done is that it has made an amendment in Article 367, whereby which is the definition clause article defining various words. Now, there it has been included that the Constituent Assembly, Legislative Assembly will mean Constituent Assembly, or wherever there is a reference of Constituent Assembly, it will mean Legislative Assembly. It is a legal fiction, and fiction means it is a fiction, it is not truth. It is not reality. A legislative assembly cannot become a substitute for a constituent assembly. But by making this law, they have made legislative assembly the constituent assembly. And obviously, once it is the legislative assembly, it is the house. Now the president rule is there, so there is no legislative assembly functioning, and that's how the government of India took the concurrence from the governor of Jammu and Kashmir and withdrew the 370. But 370 still exists. It has not been abrogated, contrary to what was being said. It's not. It's still there. I have already said that as far as the instrument of accession was concerned, for all the princely states, this was one standard form which gave the power of defense, external affairs, and communication. These were the three which had been given. Now, if you have to acquire more power, then you require all the princely states sign an instrument of merger, right? So far as Junagadh is concerned, it has neither an instrument of accession with India, nor do we have any instrument of merger. We just took it over, and the then Prime Minister of Junagadh, who was, I think, father of Zulfikar Ali Bhutto, he handed it over. That's how it is. Yes, and as far as Patel and Nehru are concerned, if you read the biographies of people written for Sardar Patel, including Rajmohan Gandhi, there was no enmity between the two. But differences of opinion can always be there, and that's a healthy sign. And many times to be prepared. Now, as far as this instrument of accession was concerned, you will find, for first is that people say that no, the Sardar was not kept in the loop, or he did not know what was happening, because there is a record where there is a letter written. That letter has been written by Pandit Nehru to Sheikh Abdullah. This is on the 18th of May 1949, this letter to Sheikh Abdullah. As far as 17th of May is concerned, the letter was sent to Sardar Patel first. And it is very clearly mentioned in that letter that only if you approve, then this letter will be sent to Sheikh Abdullah. So you can't say he did not know. Now, what was there in that letter? That letter indicates that there was more than one meeting at the residence of Sardar Patel, which had been attended by Sheikh Abdullah and his people, and also by Nehru. That means, because they were very close freedom fighters. So obviously the Prime Minister going to Sardar Patel, it's replete. There were so many visits by Nehru to Sardar Patel's residence. There it has been written that under the instrument of accession, you have agreed with these three subjects, right? And these are the agreements which we have reached. Except the king, nobody could have signed. That is why 370, and that was the anger of Maharaja Hari Singh, that my powers have been taken away. Because once 370 is applied, obviously he will be denuded of his power which he otherwise had.
We talked everything about what is Article 370, what is the impact, history. Now the most important question, what is take of Supreme Court on Article 370? What are the judgments on Article 370?
Supreme Court's history has not been very good and fair as far as Article 370 is concerned. The first judgment is of 1959. I'm forgetting the name, some call. Okay. And there the Supreme Court said that once the Constituent Assembly is already over, then 370 work is complete. It cannot be now. With the help of 370, you cannot apply any law. This is the hurdle which is coming. Today, in the definition of in 370, we have changed the meaning and definition of Article 3 of Constituent Assembly, and that's what the Supreme Court pointed out. That actually strengthens the argument which I am trying to raise, that because Supreme Court in the first Constitution bench in 1959 held in categorical terms that since the Constituent Assembly of Jammu and Kashmir is already dissolved, so thereafter 370 has no application. You can't apply. Now subsequently there was one, I think Sampat Kumar or something like this, that was in 1962, if I am not wrong. Their disposition that 370 is still survives, but you will, I am shocked that during such a small period they did not refer to this Constitution bench judgment. So that means this Constitution bench judgment still stands good law. Unless it is overruled by a larger bench, it still stands. It is very simply because you give another judgment, it will not do. Even if it is of a Constitution bench, it will still remain unless and until a larger bench overrules this judgment. And I think in 2016 or CBI case already, the 370 does not survive. You can't make use of. No, he has not. You will find if I am correct, none of the judgment has referred to the first judgment. That is still exists. Why it is not referring, I don't know. Why the Supreme Court has not been referring to the first judgment in any of its subsequent cases.
Thank you so much for your time, sir. Nothing can be explained within this period of time, but you have given a brief insight about Article 370. Thank you so much on behalf of All India Law Student Federation and with the Legal Time. Thank you.